We're going to have a discussion afterwards with Maura Conway leading it from UCD, Dublin, and then we'll open the floor for questions. So I'll try and take any of the speakers' time, and we'll start with Ian Brown from the University of Oxford.
Thanks, Pete. Remind me if you can't hear me at the back. I'm going to go quickly so that we can try to have some debate at the end of our panel, because we only have just under an hour now. So I'm talking here briefly about, you can see the title of a report that we've just published as a discussion paper from the Oxford Internet Institute where I work. I've got about 20 copies up here at the front if anyone would like to grab one at the end. And obviously there's a lot more detail in the report than I can give in this presentation. This is a project that I undertook with some colleagues, some academic colleagues and civil society colleagues, both with a European background but also with a US background, asking the question, 18 months on from particularly from the Snowden revelations starting, what scope is there for setting international standards for foreign intelligence collection in particular? So the title is surveillance reform, but in particular looking at not law enforcement, cross-border access to data and so on, using instruments like mutual legal assistance treaties, but from a technical perspective, the really impressive foreign intelligence collection that we know about from Snowden, that the Five Eyes in particular, alliance of the UK, US, Canada, Australia, and New Zealand have been doing. Of course, many other countries are doing this. Some of them in a sophisticated way, so China and Russia are often mentioned, South Korea, a small number of other countries with that sophistication of technology, although perhaps not the scale of the Five Eyes, but even at a lower level, of course, all governments, having read the Snowden revelations themselves, at least parts of those governments will be interested themselves. Should we be doing some of these kinds of things? Should we be acquiring some of these technologies or developing them ourselves, or of course buying them from companies? Despite all of the media debate, the campaigning for civil society, as you know, so far, while there is still, I think, significant public unease about the surveillance activity, foreign intelligence surveillance activities that Snowden has revealed, we've not yet seen significant legal reform. So I'm sure most of you know that in the US, Congress has been considering what's called the USA Freedom Act, which would, to some extent, constrain some of the bulk collection activities, at least of the National Security Agency, but that stalled. It wasn't able to get through Congress. We have not, as yet, seen any of the EU member states, many of whom, particularly Germany, of course, but not only Germany, that made loud complaints about what Snowden has revealed going on, actually bringing forward legal measures to both to clarify what they are doing. Of course, we now actually know a lot more about what the US is doing than we did before, but we still have a lot less clarity over what almost all of the EU member states do in this area, what the internal standards that governments have, the kind of systems that they have set up. So on the one hand, we seem in a slight impasse. I do think, though, that some of the wider negative effects that the Snowden revelations will have on a lot of other government public policy objectives, encouraging members of the public to make use of the internet for commerce, for interacting with government services, is still something very important to economic growth, making more efficient, effective government services. The status of the internet as a free and open global system, which of course the US and many of the EU countries are pushing through the Freedom Online Coalition and other international efforts. Even when it comes to cooperation between the US and the EU on law enforcement and counterterrorism, you see that the foreign intelligence collection activities revealed by Snowden have caused so much disgust that even with the European Parliament, we've seen not just one or two MEPs, significant numbers of MEPs calling for suspension of EU-US agreements, things like Sadhbh, the SWIFT agreement, and the PNR agreement, and so on. And of course, the problems that we know in terms of international human rights laws, particularly the International Covenant on Civil and Political Rights, which almost all of the countries of the world are parties to, including the US. You can see a quote I pulled out there from a recent report by the UN Special Rapporteur on Countering Terrorism while Protecting Human Rights, Ben Emerson. He said is that the bulk access parts of foreign intelligence collection we know about from Snowden I mean, this is a really very strong statement indeed in terms of international law review. Indiscriminately corrosive of online privacy impinges on the very essence of the right to privacy, which is Article 17. Since neither the US nor UK nor these other states have formally derogated from this obligation under the ICCPR, these programs pose a direct and ongoing challenge to an established norm of international law. They also, of course, are leading to pressure for data localization. It's not just people in Germany and Snowden himself that have made the points that if you are concerned about your data being, as an individual, as a citizen, or as a business, being accessed under some of the programs revealed by Snowden, well, first of all, don't use American services, don't route your traffic through the UK. I don't think some moves towards data localization are the complete disaster they're sometimes portrayed as in the technical press, and for understandable reasons by technology companies who would face significantly increased costs if they had to start building more national or regional data centers. But at the same time, clearly, this is far from ideal, this pressure that's coming as a response to the Snowden revelations. If the foreign intelligence programs are not dealt with in a way that meets the concerns that would reduce some of these pressures. So we saw debate in Brazil, but in the end, the Brazilian parliament chose not to pass the data localization law, but Russia has, and they are starting the implementation of that law, which is already throwing up problems with some of the big internet technology companies. We've seen some American companies building, or at least planning, more regional data centers, particularly in Europe, to try to assuage European concerns. But of course, at the same time, we see in the case that started in the Southern District of New York, where the US government has obtained a warrant asking Microsoft to hand over an email that Microsoft holds in Dublin, that at least from the US government's perspective, those kind of physical data locations really don't matter all that much. The US government position is it's all about effective control, and if a company subject to US jurisdiction, that's not just US headquartered companies. Any company that has significant exposure to US customers and to the US in that sense will potentially start getting these kind of demands. So I don't think that approach of data localization, even in its own terms, is effective. So, sorry, too far. Where might countries, at least the democracies that have an ongoing concern and obligation to protect their citizens' privacy, to avoid some of these negative other outcomes, where might they look in perhaps trying, from a political perspective, to meet some of these concerns, to better implement privacy protections through the human rights obligations they have and other mechanisms? Of course, there are debates, many debates at the United Nations level. So I already mentioned the Special Rapporteur report. A year earlier, the High Commissioner for Human Rights published a report on the Snowden revelations. And I think what is useful about that is that sets out, I think, some a reasonable consensus amongst most international lawyers, as far as I can tell, about what precisely those ICCPR obligations look like, particularly with controversial positions. So one claim of the US and the UK and other governments has been, well, the bulk collection of data in itself does not intrude upon privacy. It's only when intelligence analysts start looking at the data on screen, picking out individuals and looking at their data on screen. That's not at all the position under the ICCPR. The collection of data starts intruding on the right. It's not just a human being looking at it on a screen. There are important principles in international law on legality, necessity, and proportionality, and especially to do with secret rules, secret interpretations, even if they're secret judicial interpretations, do not have the qualities of law that international law require. That sharing of data, as we know, is at the very least has been happening in the US between intelligence agencies and law enforcement agencies. We saw the Drug Enforcement Agency being fed data from the NSA and then using that in court cases without revealing to the court or to the defendants where the data had come from, is very problematic. And finally, the interlocking network of intelligence sharing agreements we know not just the Five Eyes countries have, much more broadly than that, is also potentially problematic, especially if governments are using that to bypass restrictions on domestic intelligence collection. country A's intelligence agency is not allowed to conduct operations against its own citizens, but in effect it's asking country B to do it for them and share information through these information sharing agreements. Very, very problematic, again, on the lawfulness side. There have been some moves at the UN to start putting pressure on states to live up to these standards. So I'm sure you're aware of the resolutions that have been passed by the General Assembly, pushed by Germany and Brazil, but a whole range of other countries have supported those. But you can see one of the key parts of the resolution passed in 2013, and a similar resolution was passed at the end of last year. They call upon states to review their procedures and practices, but there was a limit to how far the General Assembly could agree they should go much further in terms of specific operations that had been revealed by Snowden. The US and the UK and other countries lobbied very hard within the Assembly to limit how far these resolutions would go. We have the Human Rights Committee at the UN level, which is the authoritative interpreter of the ICCPR. They made some very critical comments in their periodic review of the USA's compliance with the convention in 2014. Having made the complaints then, where do you go from there, of course? And then at the Internet Governance Forum in 2014, you can see the quote there from Amnesty International. Civil society got these issues on the agenda, but governments did not choose to engage with them. So, where to go from here? What we've done in the report is to look at 4 of the most substantive reform proposals that have been put on the table in this area. One of the most detailed ones actually is President Obama's own commission, which reported at the start of 2014, made 46 very detailed recommendations. Some of those have been implemented through the Presidential Policy Directive 28. I think actually that, taken as a whole, those 46 go a very long way in meeting some of the concerns that other governments and civil society groups have about what's happening. I'm not saying by any means perfect, but there was a real limit on how far the US administration was willing to put those into practice. We've had the Civil Liberties Committee of the European Parliament inquiry, of course, but there you have the big issue that under the EU treaties, the member states have competence on national security. We have the principles that civil society groups, several hundred of which now globally have signed up to, these 13 necessary and proportionate principles on surveillance. I think those are a really good starting point for a global discussion. I think we need more engagement from governments, and particularly from counterterrorism and intelligence agency personnel, on how some of those in practice might limit the ability to do targeted investigations. And then finally, we have in the technology sector 5 principles for surveillance reform, which I think are a good start, but unsurprisingly they're concerned about privacy of those technology companies' customers from governments, not so much from the companies themselves. And I don't think you can so cleanly separate those issues, not least of course because if companies are collecting information about their customers, they're very likely to be under legal obligations to share that under certain circumstances with governments. So what we have suggested in this, so that our report is not at all a recipe for the perfect global agreement. It's a review of what's been done to date, a comparison of these reform principles, and then a suggestion of a process by which this kind of debate can hopefully happen, ultimately at a global level, but we suggested, given the difficulties of this at the UN, because of the very different positions of many different countries on these issues, starting at least with North America and some or all of the EU member states that do have strong shared values on privacy and protecting freedom of expression, other online rights, as well as economic interests in ensuring people continue to trust internet use, that those states start discussions about what an international instrument, whether it would be a convention, something else, might look like, what kinds of principles they can agree in terms of making sure that intelligence collection of data remains necessary and proportionate, in the words of civil society. Thank you. It's back there, so they'll bring us up in response to controls.
Right, so next up we have Sadhbh McCarthy from the Centre of Irish and European Security.
Okay. Oh, okay. Great. Thank you. So, Well, thank you very much. This presentation, I hope, to some extent complements actually what Ian has been speaking about, because Ian's, I think the work is sort of at a macro level of understanding it in international cooperation. We've been working recently in a more, first of all, it's at the more policing side rather than the intelligence agency side. And also this is kind of an abstract conceptual framework that we're working on to try and put something around the issues that Ian has raised here and that are constantly being discussed when it comes to how do we manage the policing of the internet or the, let's say, the digital world, whether it's through social media or otherwise, in a way that's actually still respecting citizens' rights and so on. And I just want to go through sort of a little bit of how we've started thinking about this. My background is predominantly in the security research field, the European Security Research Programme, which has been going for about 10 years now. And when I started first, the way we thought about it from the perspective of the civil society agenda was about data protection and privacy in a very legalistic manner, in a kind of framework of what Peter Burgess often describes as mismanners. Is something allowed or is something not allowed? Can you collect the data, can you keep it, can you retain it? And that worked pretty well at the beginning, except as things progressed, there were more sophisticated challenges associated with what the security instruments being implemented were. So around 2009, 2010, we started looking at what we described as more societal impact, the broader context of the security instruments that were taking place and the type of policing that was taking place to manage the security threats as as they perceive them, mostly to do with violent extremism or terrorism, in all honesty. And the societal impact framework was much more rights-based. It was really looking at not just are you obeying the law, but in addition to that, is what you're doing having the potential of starting to undermine some fundamental rights, whether it's freedom of movement or freedom of assembly or freedom of speech, in fact. And that has worked quite well, but it's still coalesced somewhat around the notions of privacy and the right to a private life, and hasn't really moved as far as we'd like it to into a broader, more nuanced perspective. So we started working on something called societal governance. I'm not sure if governance is the right word. I think governance is a complex. The governance scholars will tell me that this is not correct, but we couldn't keep calling it societal X. We had to call it something. So societal governance it is for now, which obviously still incorporates the data protection and privacy, the legalistic framework, the societal impact dimension, but is trying to go somewhat further in thinking about it. So in trying to look at this, we started thinking about security measures, what we're doing in terms of surveillance, and this is the sort of at the operational level, the specificity of what the police might have to do. Does it meet the tests of transparency, accountability, and legitimacy? So the transparency is the process that's being undertaken by law enforcement transparent? Can we understand it? And it's really important to know, we are not asking that they tell us what they're doing in the content sense, that who is being targeted and whatever, but that the process, the bureaucracy around the activity of surveillance is transparent and we can see it. Are they accountable if it goes wrong, or if there's some issue with it that somebody's rights are infringed? Is the police service, is the law enforcement agency accountable for the action? And is it legitimacy? And legitimacy is not legal, and I think in some ways it meets to some extent. It's a little bit like the term lawfulness that I think Ian was using. It may not be exactly like that, but it's kind of complex to understand whether something is legitimate beyond whether it's just legal. And there's some work been done on this in a project called Cecile, which was looking at counter-terrorism measures introduced since 9/11. And so there's some quite extensive research that's been done on that, which I would refer you to if you're interested in this, the thinking on it. What you have when you have legitimacy, transparency, and accountability in relation to the policing action and the policing activity, it is the development of a trust relationship between the citizen and the state. And that is really important. I mean, we're not going to have a successful democratic society if there's this tension between the citizens and the state, that people don't trust the police service and the police don't trust the civil society advocates who are trying to represent the voice of people who have concerns. And this is what we're thinking of as societal governance. Now, in the context of societal governance, as opposed to data protection, privacy, or impact, the increasing use of technology to instrumentalize citizens with or without their knowledge, and specifically within social media, has the potential to be very problematic. So what I mean by that is instrumentalizing citizens is where the law enforcement agencies are actually starting to use citizens as extensions of their own power and what they do. So when they use our data, when they use our data without our knowledge, so when they're looking at Facebook or Twitter, whatever we put out there, when we're being observed without our knowledge, and I think somebody was talking in the previous panel about things like body cameras, those are and video images have been taken. That is all information that's been collected and used and interpreted without our knowledge. And then sometimes we also engage that, this idea that things are reaching out and asking you to engage through Twitter or Facebook. Again, that's asking you to become an extension, which is fine as long as you understand it. So I think I'm working towards we are working towards the idea that the difference between societal impact and societal governance is that societal governance is trying to bring in the concept of power disparities. So when the continuous unhindered flow of information and data has become the ultimate objective of securitizing actions, right, to the point that the citizen is the new center point for data collection, that's a problem. And I do think that that top point about the unhindered flow of information and data is the objective. They stop trying to work out what it is they're trying to do in the first place. Who are you trying to catch? What are you trying to stop? And the objective has become, we just want the information, we just want the data, and we worry about what to do with it later. There's a common response from law enforcement that says, don't be ridiculous, we don't have the resources to collect all the data and process it. Are you crazy? We're only focusing on the bad guys, the ones we have evidence to work on. But that's fine, except that the principle still remains that they're collecting everything. And if all they're hindered by is resource, then the day that they have the resource, they can do the things they said they would never do, and that's very, very difficult. So societal governance is starting to explore these points through the lens of power as opposed to through the lens of just the law. And somebody will tell me, and the law, a side point, somebody would say, well, look, lawyers and teachers will say, well, the law can manage these issues, but the law isn't necessarily completely fair either. There is sort of a power disparity in the way the legal frameworks are made. So I sort of just referred to this previously, so it's from the same point. But it's just the citizen is a passive participant, where you're just observed, your data is observed, the content is observed. Citizens can be active participants, where they actively engage with law enforcement agencies, they sign up. It's a bit like being in the residents association. And the conduit, they're all telling me to stop talking now. The conduit between the community and law enforcement. One of the interesting things is when you have this engagement with citizens through social media is a bilateral tool. So you have the law enforcement agency talking to the citizen talking back, but the citizen can also be reporting on another citizen. So they're saying, oh, that guy looks suspicious. So the surveyed becomes the surveyor as well. That sort of triangular relationship. And then there's the citizen as data point. That's where just, in an anonymized sense, just the fact that you're in a position, the geolocation of your phone is giving the state information that they're taking from you because you are in a particular place at a particular time in the technology. So just back to societal governance, the legal model doesn't necessarily address all the concerns, the rights-based model doesn't always do it, and the societal governance model is trying to incorporate both, but it's trying to look at the more nuanced issues of rights and responsibilities. So the responsibility of the citizen to act in a manner which is consistent with the good citizen in the state. Of course, that gets issues around what's a good citizen, what's a bad citizen, but that's a whole other presentation. But also the sort of the rights that the citizen has, within that state, and who has the agency in a relationship between the citizen and the state, when the state is managed through data and content. So what I'm really trying to say there is, when you sign up for, say, Facebook, or even when you sign up for something else, it's like when you're asked to sign a form in a hospital agreeing to a surgical procedure. You cannot be giving informed consent. How on earth would you be able to know what the risks are? You haven't spent 20 years practicing medicine. You're trusting that the doctor who tells you that it's 97% safe is right. In the same way, there is no such thing as informed consent if the citizen couldn't possibly have the understanding of the implications of what they're doing that the state has. And then, of course, there's the issue of technology push. I'm not going to go through those because they have to have time, but there are some good practices. The PSNI actually have a really interesting 4 pillars of modern policing and how to implement social media. But that's it. But so there are legitimate requirements on law enforcement agencies to use social media intelligence to identify, prevent and pursue, particularly in relation to violent extremism, which has been played out to a large extent online. But they need to do more than just meeting a legal requirement and more than just ensuring that fundamental rights are observed. We need to have a trust relationship that ensures that people actually feel like they have agency in how the police are doing their job and how the police are using them in the doing of their job. Thank you.
Thanks very much. Thanks a lot, and over to TJ McIntyre from
Hi folks, yeah, so as Pete says, in addition to University College Dublin, we have a small civil liberties group that hopefully you might have heard of, called Digital Rights Ireland. But I want to talk about something other than data retention for once today. I want to introduce to you the idea of internet filtering, the way in which it's being carried on a extra statutory, quasi-public, quasi-private basis, and the impact that that might have for privacy. I'm told I have a very short period of time available to do so. So in fact, it might be useful to start at the end. You might have seen these types of headlines popping up in the media recently, showing that Google, for example, has been making reports to law enforcement where somebody has emailed an image of child abuse to somebody else, where somebody has uploaded a child abuse image to their Google Drive or to their Microsoft SkyDrive or to other forms of cloud storage. And you might be wondering how this has happened. Well, it's something that has happened, going back a slide, in the United States since 2004, and something that's essentially a model for everything that's followed. This is a diagram showing how America Online in 2004 introduced what they call the IDFP, or image detection and filtering process, which takes known child abuse images, it applies an MD5 hash, that is to say a fingerprint of the file to those images, and then it looks out for other images sent through their email systems, uploaded onto their various online services, their various platforms, and if it spots a report, if it spots a hash match, it automatically generates a report which goes to this American body called the National Center for Missing and Exploited Children. That in turn forwards the report to the relevant local police agency in the States, who in turn get a subpoena requiring AOL to identify the subscriber, and then somebody gets a knock on the door at 6 o'clock in the morning. The significance of that, apart from the fact that it's been going on since 2004 with very few people knowing about it, the significance of that is the way in which it uses the private sector, AOL, to outsource the surveillance process in a way that the US government itself wouldn't be able to do, probably, consistent with the Fourth Amendment. However, once AOL discovers that somebody is transmitting such an image, there is then a mandatory reporting obligation on them to report that image to police via this National Center for Missing and Exploited Children. Why do I start there when the focus is on terrorism? Well, I start there because increasingly, even in the last few days, you're seeing suggestions for similar systems to be put in place in Europe. You might have seen the reports, and I'm sorry that that's cut off at the top there, but you might have seen the reports coming from the UK in the last few weeks, particularly following the publication of the report into the murder of Fusilier Lee Ripley, which have attempted to place the blame for that killing on social media. Those reports have seen the UK government say, in effect, that Facebook was at fault. They knew that these were radicals, They took down chat postings, but didn't report them to police in the UK or to the intelligence services, and they should have done so. So the suggestion is there that social media platforms should be automatically required to hand over data to police, where, for example, they remove a posting on the basis that it violates their terms of use, it advocates legal violence, or indeed, even if it doesn't necessarily advocate legal violence. This is the exact language which was used, presumably reflecting UK government leaks in the last few weeks. And the suggestion was that social media companies would be obliged to make these reports not only in respect of illegal material hosted on their services, but also inflammatory material that does not necessarily break the law, but could contribute to the radicalisation of vulnerable British Muslims. So the proposals are for really quite an astonishingly far-reaching duty to be imposed. Now, many people have said it's not really credible that such a system could come into effect, that it wouldn't be consistent with, for example, the protections imposed by the Electronic Commerce Directive against generalised monitoring of internet systems. The reason I introduced the child abuse image system to you was to illustrate that, in fact, it can very easily come into effect. We know, for example, that the e-commerce directive doesn't preclude the imposition of monitoring reporting obligations in particular instances. And it would, I think, be easy for the European governments to mirror the approach taken by the US government in imposing a reporting duty on top of whatever moderation is already being carried out. So the moderation itself wouldn't necessarily be subject to public law because it's being carried out on a private, contractualized basis by social media firms in Europe. But then, once they get information, they would then be subject to a duty to report that information to police. Why do I say that the monitoring itself wouldn't be subject to public law? Well, again, because it's already happening in a way that I think not many people are necessarily that aware of. And here I have to rewind slightly. And I want to rewind as far as 2008, when the UK government, in conjunction with internet filtering companies, introduced a system whereby the Home Office would make a decision about the legality of a particular website. It would then pass on a list of URLs to be blocked to filtering companies, and then filtering companies would include those URLs in their lists. The aim behind this was to, again, it was an anti-radicalisation measure to protect the vulnerable, and the idea was that it would be deployed across the public estate, meaning libraries, universities, immigration removal centres, for example. It may also be something that's deployed in lists that are used in a private context, family filters in the home, for example, but we don't know because the Home Office has refused to reveal to what firm it gives the list. Significant aspects of the system, well, one is, you can see there, is the idea of a confidentiality deed with industry. So the industry itself is precluded from talking about the system or revealing that the Home Office has been blacklisting certain materials. And that gives you, from a lawyer's perspective, a very unusual scenario, which is that you have criteria of legality being used, glorification offences, material information which is of use to terrorists is being blocked. But we don't, it's not a decision which is being made by a court. There's no statutory basis behind that decision. There is no fundamental rights analysis or privacy impact analysis being carried out prior to the system being adopted. As I said, we don't know what firms are taking part, and the Home Office has been very keen to keep that under wraps. We don't have any question of fair procedures. Sites aren't notified in advance that you will be blocked by this Home Office scheme. They're not given any notification after the fact, and they're certainly not given any right of appeal. I brought an action to the first tier tribunal in the UK last year, where I sought information under FOI about the system, and one of the things I said was, well, there's a very important public interest here. What happens if a site is wrongfully blocked, and Amazon, for example, finds it's inaccessible to a lot of its target market in the weeks running up to Christmas? Surely there's a big public interest in knowing, A, what steps are being taken to prevent that, and B, is the taxpayer going to be on the hook for those damages? And the Home Office response was, we don't make mistakes. I'm not kidding, that was the response, we don't make mistakes.
We all say that, do you?
I'm sure that's correct. Do we know how many sites are being blocked? They wouldn't tell me under FOI, but they did say in Parliament recently that we were looking at approximately 1,000 items, whether that means 1,000 pages, 1,000 sites, 1,000 discrete videos. We don't really know. But it raises very significant concerns, obviously from a legality perspective, but also, as I said, from a function creep perspective. Because once we have a system to designate material that is illegal, once we have a system to block access to that material, then that system is also a means of identifying the IP addresses, the people behind those IP addresses, who are trying to access that illegal material, which in turn is a basis for mandatory reporting of details about these people, or further investigation of these people. And I'd like to close with a quote from the recent report into the murder of Fusilier Weekly, where the UK Intelligence and Security Committee, the parliamentary oversight body, was deeply critical of the security services for failing to engage in intrusive monitoring in situations where one of the individuals, one of the murderers, had been viewing Inspire magazine online. The security services had said, well, the mere fact that somebody has viewed Inspire magazine online isn't a basis for us to take intrusive measures. Now, what did they do? They did monitor their telephone calls, they did monitor their social media and internet use generally, they did look at their connections with other people, but these fell short of intrusive measures, which unhelpfully aren't defined in that report, so left to our imagination. But the clear view of the Intelligence and Security Committee was no. The mere fact of, as they put it, engagement with social media, reading Inspire magazine, for example, even if the act of reading it is not in itself illegal, would be a sufficient basis for intrusive measures to be taken. So to that extent, I think it's important you tie together the idea of blocking with the idea of privacy and surveillance. A blocking system is not just a system that stops people viewing things. A blocking system is, unless it's very carefully designed, a system which tells you what certain types of people are trying to read. And that in turn, in the official view of the Intelligence and Security Committee, is in itself enough to justify the use of the rather Orwellian sounding intrusive measures against them. And that is of some concern to me. Thank you very much.
Last speaker now is Robindra Prabhu from the Norwegian news.
Right, so before I start, the Norwegian Board of Technology is an independent public body based in Oslo, Norway, and our mandate is to advise the Norwegian Parliament and governmental bodies on the societal implications of new and emerging technologies and their impact on society. So we work in many different fields, and one of them now is the topic of security and openness after the terror attacks of 2011. Many of you will know that Anders Behring set up a bomb at the government quarters. He killed 8 people there, injured a further 200, I believe, and then he went on a shooting spree on the entire island and massacred 69 people there and injured just as many. So I'm not going to talk about that event, but what I'm going to say is that events like these are very often catalysts for change in societies, for better and for worse. And we know that modern technology has tools that can allow us to safeguard society in absolutely new ways, enhance our capabilities to do so, but it can also challenge in very real ways our notions of privacy, civil liberties, openness and transparency, some of which are also in flux and change. So I'm going to try to give you a sense, my own personal take on the public debate on internet surveillance after these events, and then if there is time, I'm going to talk a little bit about open social media surveillance and open policing, and some of the sticky issues that we encountered there in a report that was just recently released. So most Norwegians remember these words by Ben Piracy and Stoltenberg, and I remember I was very relieved to hear that this was to set the political, the tone for the political response to these events. But he also added, we will not be naive. And if before the event, the feeling in Norway was that the internet was, really a force for good, something that allowed, freedom of speech, gave everyone a voice, really, really a positive story. After its attacks, I would say that there was a sense that we had to change that narrative slightly, if not modify completely, that there was a dark and sinister side to the internet that had given rise to a monster, and we needed a Norwegian response to that. So the debate, I would say, forked out in different directions. One of the immediate ones was dealing with anonymity online, and that was, if you looked at the comment fields in a lot of the online newspapers in Norway and I guess many other places in the world, there was a lot of hateful speech, a lot of very aggressive language, and after these events there was a sense that these media channels had some responsibility in curbing these sort of comments. And I think now, although I haven't done a thorough check, I think you'd be very hard pressed to find any other major newspapers where you don't have to sign up with your full name or sign up with your Facebook account in order to post any comments, and which aren't moderated. So that is one change. There was also debate very related to internet trolls and whether we needed techno fixes to filter these sort of things out. And then a third prong, if you like, on internet surveillance, because Anders Breivik seemed to be born on the internet, someone who found his echo chambers on the internet where all his views solidified. He was active on social media, and there was a very why was he not picked up on? He left all these traces on the internet. So a lot of people actually were wondering, could he have been stopped if we had some measure, some way of monitoring his activities in whatever way or form online? And I think a lot of people were, the first response came from the Norwegian security police, and they in their own evaluation said that there were things they could have done differently, but probably nothing they could have done that could have prevented the attacks. And that conclusion was, I think, surprisingly to a lot of people also supported by the commission, which said that, a lot of things went wrong. There was a lot of damning criticism of the police and also of the way that things were handled that day by the Norwegian security police, but nothing to suggest that online monitoring of these online activities would have been able to prevent the attacks. And I think, just need it. Some of the complications around this are very, very nicely summarized by Robindra. I guess you can't read the address there, but if you do visit the VOX-Pol website, you can find this blog post, and it's a very interesting read. And he said, well, actually, Anders Breivik never really discussed his terrorist plans online, and a lot of these critical views on Islam were actually established long before he started interacting with these counter-jihadi blogs. And many of the comments that he did make were actually very similar to the sort of stuff that you find on online newspaper comment feeds, etc. So there's a sense in which the internet definitely gave him the knowledge and the ingredients and to carry out these attacks, but nothing to conclusively say that gave him the idea to carry out the attacks. And I think it really sort of summarizes the complexity of the whole process and how hard it is to devise frameworks that would actually allow us to monitor and capture these sort of cases. Still, even though it was concluded that they couldn't have stopped him through tighter monitoring, they did leave I'd say, at least the public debate in the centre didn't go for it, because they said, well, the Norwegian security police service is still very poorly adapted to the digital age, to the internet, and they should have prioritized open source intelligence to a much larger extent than they had, and they really shouldn't hold back on following radicals online for fear of being criticized for political surveillance. Whatever following online really means, that's not entirely clear. There's been a debate about what that really means. There's been some money given to strengthen the activities of open source intelligence. There's also been a proposal to move towards sort of big data analysis, whereby you use not to drill down on an individual level, but for sort of for monitoring overarching trends, predicting future events, which has been I think shot down in the public debate. How am I doing for time? Right.
2-3 minutes.
2-3 minutes. Okay. So where do we go from here? Well, our take on it was, well, let's start with open policing, which is a little bit easier. Now, this is a lot of police stations in Norway have had a lot of success using social media as a communication platform to the public, telling the public what they are doing. This is the Twitter feed of the Operation Command in Oslo, and it's actually the 5th most followed Twitter user in Norway, so hugely popular. But as said, we're not really a top-down society in the way that we were. We now, we're a sensor-based society. We're equipped with smartphones, we carry them with us all the time, and we create new digital streams within this network, which can fuel, which can contribute to the situational awareness of policing. So we've been looking at how social media might be an information channel to the police, especially when something major is about to evolve. Right, so this is just an analysis of the Twitter feed on the day of the terror attacks. I don't want to go into the details here, I'll just say that, there was a lot of activity, some of it containing pictures, images, video, live from the scene, which could be very useful for situational awareness. There's a steep rise in the cumulative number of tweets, which is basically a digital signal for something that something is happening. This is also happening as as things are unfolding. So you have a continuous feed from the public, from the people on the scene, before you arrive and just when you arrive, before you actually establish a picture yourself. So hugely useful. And when we ask whether the public, whether they think that the police should monitor these sorts of words, about 2 in 5 say yes. But when we ask the same people, sorry, you can't see that, but would that change your behavior if you knew that the public, if you knew that the police were monitoring online social media, would that change the way that you actually use these tools? And then, yeah, 2 in 5 say that they do. So you have to worry about a chilling effect on these media, and I think a lot of that has to do with really clarifying what open information really is, understanding that technically open information doesn't necessarily mean that it is public in common sense of the word. A lot of what we do online might be technically open, but really exists in a grey area where people don't believe that it's strictly private, but also not fully public, and they don't actually understand the implications of what they're publishing. So our few recommendations were to, yes, do start off in open policing, use it for situational awareness, but be very clear about what you consider to be open. Use it only for aggregate data for situational awareness. Don't drill down to individuals unless you're in an investigation. We're holding back on using this for investigative purposes. And then finally, build in privacy preserving features when you can, such as facial blurring, etc. Okay.
Hello, it's Maura Conway from UCD, Dublin.
DCU. UCD is TJ McIntyre. DCU, Dublin City University. Thanks, Keegan. I guess we'll start. We don't have a whole lot of time in our hands, but we have about 15 or 20 minutes. So if people raise their hands and identify themselves, we'll go from there. Questions? You're all astounded. Go ahead.
Hi, Christopher from Ecuador. I had a question for the UK blocking of website. Is it a list of URL? Is it blocking by DNS? Is it including? How do they implement that?
Okay, as far as I can tell, and it's very hard because you're prying information out of them, as far as I can tell, it's a fully URL-based system rather than a DNS block. On the other hand, Ireland just last week introduced a similar system where, again, no legal basis, no statutory basis, where it's based on DNS blocking from the police. and DNS blocking tends to be much preferred at the ISP level just because it's cheaper and smoother. And
you see, even between the ISPs in the UK, they also block materials they've been ordered to as copyright infringing, like by the High Court. And some of them use DNS blocking, some of them have their own deep packet inspection equipment to do it. So.
Richard Tynan, Privacy International. We now know that extremists are really investigative journalists in the minds of GCHQ. So in that context, do we actually think that monitoring of the internet for extremist material is a good idea at the moment?
I think that's a TJ question.
Well, you know that the David Miranda judgment confirms that the investigative activities of The Guardian were capable of being terrorism for the purposes of the Terrorism Act.
Yes.
And the current independent reviewer in the UK has said the Act is being used in an extraordinarily wide manner at the moment. Some of his words, not mine. So the idea that you're going to stretch it further again by extending it in this non-statutory way is even, to my mind, even more worrying.
And it's also a reminder, of course, that adding judges everywhere to a process does not necessarily give you the protections you need, because this came from the High Court. It was them looking at Miranda that decided it was withdrawn. Was there a question near the front? Yeah.
Yes. Terry Schultz, I'm a journalist, extremist. No, it makes me think twice about looking at Aspire often though.
Yeah.
Serious. To the UK question. It started back in 2008, and we weren't talking about it so much back then as we have now. How do we know how many of the ISPs are complying? And why do you think they don't come out and complain? Because there would be public, I think, empathy with them being forced to do this, I would think. But again, now, I mean, just in the last 2 weeks, that may change. There's terror threats now, everybody's afraid, and may want more monitoring. I don't know. Why do you think that the big providers, that Google, YouTube, aren't complaining more publicly about this? What sort of voluntary measures are being imposed on them?
Okay, well, there's two things there. There's a hosting perspective and there's an access perspective. From the hosting perspective, Google, YouTube, other platforms are happy to remove lots of material anyway, even if it's not necessarily illegal, once they see it as being in breach of their terms of use. So in 2010, the UK government started this process. They took down approximately 90,000 distinct pieces of content from the Google platforms.
In 1 year, or just when this first started?
Just in 1 year.
That's the first wave.
In the first wave. And that's quite an easy thing to do. You don't have to say this is illegal, you just have to say it is in breach of terms of use, it is hateful. Now, the second question is about connectivity and filtering access. Why aren't the ISPs complaining? Well, it might be that the ISPs don't even necessarily know that they're using this particular Home Office list, because the Home Office isn't giving a list to TalkTalk and Vodafone, etc., and saying, please block these sites. The Home Office is giving a list to the companies that make the filtering software, which is usually being used at an end user level, a business level in universities, libraries, etc. But we only know of one filtering company that uses the list. We don't know what the other filtering companies use, and we don't know if the ISPs are buying their family-friendly blocking systems from those filtering companies. So you don't know. If you have a mobile in the UK, there is a family-friendly block on it by default until you prove you're over 18. So if you try to access tjmcintyre.com, you might be told, sorry, you can't get through to it. You don't know who's responsible for that. If you did know the filtering company that provided the list, you wouldn't know that the Home Office had told them to block access to my site.
But when they first called them in, the meeting you mentioned in 2008, why didn't they come out and say no and tell all of us that they've been asked to do this, and other than the illegal sites that you mentioned that they were having to take down? Why do you think they didn't come out and say this is a violation of your free speech public?
Because they need a positive regulatory environment.
Yeah, I mean, if you think they're just buying into it when it's convenient.
I think the only thing that has changed recently is in the wake of the Snowden revelations, there's an element of pushback on behalf of consumers.
I mean, we did another, in addition to what TJ said, one way that we have got to this point in the UK, as TJ started with, it started with child abuse images, which BT over 10 years ago decided it was their corporate social responsibility to block. So they did that, pretty voluntarily, I'm sure with some pressure from the government. And then having done that, of course, they set an example to other ISPs. The government put more and more pressure on those ISPs to do it. So within a few years, I think the figure quoted in Parliament was ISPs with 97% of the retail market were doing entirely voluntary blocking. Having done that, of course, then the High Court started weighing in and granting injunctions to copyright holders that the ISP should use these systems they'd already put in place to block access to these sites also, because you can see it in the judgments from the High Court. The ISPs tried to argue it was an extremely onerous burden that would have been placed on them, and the High Court said, you're already doing it, do more of it. And I heard exactly the same thing last summer. So it's not just copyright now, it's also trademarks. The High Court last summer granted an injunction for the first time to luxury goods trademark holders, where again the ISP said this would be very expensive, very burdensome. Where would it stop? There might be millions of websites which are infringing trademarks. And the High Court said, look at the family-friendly filtering that you are putting in place by default for all of your customers. Again, as a voluntary agreement with the government, you already are filtering tens of millions of sites in some cases. The High Court just won't believe that adding these kinds of sites to that list is a burden on the ISPs.
And from the data protection perspective, Max Mosley, who everyone knows is the man who was not involved in the Nazi orgy, is very keen on adding sites containing his videos to that list as well. And, there is, I think, if anyone has a case, nothing particularly sympathetic to Max Mosley, but I think he has a fair argument in that, there's a much better argument for this sort of dignitarian blocking of material that infringes people's privacy, child abuse images being the extreme example of it, than there is for any other type of blocking. And of course, as everyone knows, data protection blocking falls outside the scope of the e-commerce directive. You can do it to your heart's content.
Back.
My name is Nigat from Digital Rights Foundation, Pakistan. I think in this whole debate, the role of corporations like Facebook and Twitter is really important in blocking the content, and especially in a country like ours where the war on terrorism is going on, and whatever the regulators, the Pakistan Telecommunication Authority or the Ministry of Information Technology, whatever the blocking request they send to
5 minutes is still.
They send to Facebook or Twitter, they exactly don't know what it means, illegal content or anti-state content. And they block it because they think that the terrorism is like too much in Pakistan, or they are on the war on terrorism, so they they feel obligatory to block it without getting any other second opinion. And that's actually happening a lot in recent years and in recent months. So I'm just wondering that how these corporations can sort of make better their policies while also communicating with the civil society or the digital rights activists who are working in these countries, not only with the regulators and the government agencies.
I think it's an interesting example of Pakistan, and maybe India and Turkey are in a similar position to some extent. And I think there's a tremendous amount of hypocrisy from a lot of critics over here about blocking there, where at least the blocking there generally has some sort of statutory framework in place, as opposed to particularly the UK, Ireland, a number of other continental countries here where there's no statutory framework at all, and we're making it up entirely as we go along. But in terms of the cooperation with the individual companies, I think to a large extent blocking is dependent on that cooperation. That Twitter, for example, is willing to produce a localized feed which has been censored for the benefit of individual jurisdictions. If they take away that, you leave the countries involved with a stark choice: block the entirety of a very useful service and all protest that goes with that, or let the entire thing through. And you see that obviously in the choices made by Google in their participation in Hong Kong and then in China. So maybe to a large extent there is a question there: is the company in question willing to stand up for rights at the expense of potentially losing access to an entire 20 million people, 60 million people, nearly 1 billion people in a particular market? And so far, unfortunately, we know the answer to that.
I'm wondering, has there been in the UK a debate
whether it would not be better to actually investigate and delete the child abuse material rather than just block it?
In the UK, no, it's been overwhelmingly been in favour of blocking it. We haven't seen the sort of debate we had in Germany over the blocking laws.
So within just a tiny bit more detail, if this material is hosted within the UK, then the industry self-regulatory body, the Internet Watch Foundation, will contact the host to get it taken down. But if it's outside the UK, it's blocking. They have been discussing sending reports to the hosts overseas, but I don't know how automatically they're doing that yet.
I'm from the Netherlands, and I can add to that in the Netherlands we have been fighting internet filtering as well. And this freedom has been using the argument that if you leave the image online and just filter access to it, then the police doesn't have a urge anymore to investigate a case. So by saying that that the government should, that the police should actually investigate the case and have the images removed instead of just blocking access to it, that has been an argument which was accepted by, for example, the Dutch Parliament. And that was that's the main argument in the Netherlands for not having internet filters on sexual abuse of children right now. So that argument did work, did help us to a large extent.
Anybody else with a final intervention? If not, I'll just say 2 words, because a lot of people seem to be interested in this question of social media companies and sort of corporate responsibility, violent extremism, etc. The VOX-Pol, the project that I'm responsible for, that people here are involved in. We are actually having a workshop in Budapest in March, in which we are going to discuss precisely this issue of the role of social media companies in responding to violent online extremism. So if anybody has a particular interest, you just check out our website, and the information is there. Otherwise, I'd just like to say thanks on behalf of everybody here, everybody